Lesson 3. Incapacity. The ministry of the judge is a ministry of charity towards the ecclesial community, which is preserved from the scandal of seeing the value of Christian marriage being practically destroyed by the exaggerated and almost automatic multiplication of declarations of nullity of marriage in cases of the failure of marriage on the pretext of some immaturity or psychic weakness on the part of the contracting parties. St. John Paul II, 1987. 1. Anthropology. If the contributions of canon law can be compared to medieval cathedrals, we are going to visit one of our finest buildings. The Treatise on Matrimonial Consent is among the most accomplished products of our canonical tradition. Indeed, since divorce was not an option, the question of invalid consent became central for Catholic thought. But before we start our tour, we need to visit the foundations of the cathedral. Matrimonial canon law is built on a particular anthropology, on a determinate understanding of human beings and human actions. Here is a basic summary. Like God and his angels, humans have logos, or reason. Like other animals, we have a body, a sensible nature. Hence the definition of human, zoon logon echon, animal who has reason. And like God, we don't know everything all at once. Our knowledge is discursive. And like other animals, we are capable of abstract knowledge, and we can moderate our own instincts. We are peculiar beings at the crossroads of divinity and creation. Our senses perceive the world and provide this information to the intellect. This is our inward dimension or apprehension. We perceive or apprehend the world in two ways, sensibly and intellectually. Our outward dimension or appetite is also twofold. Our appetite can be either sensible or rational. Our sensible appetites are our instincts and emotions. Our rational appetite is called will. When our intellect and will are not engaged at all, our actions are not really human actions, but merely actions of a human. For instance, if a hunter shoots a friend, taking him for a deer, he is not a murderer. A homicide, the death of a human, took place, but there was no murder. The hunter had no will to kill his friend. The homicide was the action of a man, but there was no human action, in the sense that there was no intent to murder. These notions may seem a little abstract now, but they will come in handy in the following lessons and in your work as an advocate. 2. Incapacity. We are about to enter the cathedral of the null consent. In front of us, we have the main nave of incapacity. On the sides, we can see the two naves of the defect of consent that come from the will and from the intellect, respectively. We will visit them in lessons 4 and 5. For now, we are going to focus on the grounds of incapacity. Incapacity is regulated in Canon 1095. It contains 3 numbers, 1 for each ground. The following are incapable of contracting marriage. First, those who lack the sufficient use of reason. Second, those who suffer from a grave defect of discretion of judgment concerning the essential matrimonial rights and duties mutually to be handed over and accepted. Third, those who are not able to assume the essential obligations of marriage for causes of a psychic nature. Incapacity takes place when a grave psychological anomaly affects intellect and will to the point that the person is unable to elicit a human act of consent. Notice that incapacity is always based on a grave anomaly. If there is no anomaly, there is no incapacity. Without significant anomalies, human adults are capable of marriage. Therefore, the first step is to identify the grave psychological disorder that rendered the person incapable. In the last decades, the popes have stressed several times that incapacity is always caused by a grave mental anomaly. The anomaly is a serious psychological problem that limits the capacity to understand and to make choices. In cases of incapacity, the question is not if marriage was the right choice. The question is if the person was able to choose marriage. In this sense, incapacity is not difficulty. The incapable are unable to marry. They cannot marry even if they want or if they try with all their strength. Incapacity is not immaturity either. Certainly, a grave pathological immaturity could be that grave anomaly that renders the person incapable of marriage. This incapacitating immaturity is a pathology, a psychological disorder, which is very different from the common notion of immaturity. To some extent, on the day of the wedding, everyone is immature and unprepared for marriage. However, the maturity required to marry validly is the minimal maturity necessary to establish the rights and duties of the marital bond, not the ideal maturity needed to lead a successful and happy marriage. Ecclesiastical tribunals employ experts in psychology to assess the anomaly. We ask them to assess if the person suffered a psychological disorder at the time of the wedding. If the expert finds a disorder, we ask about its nature, typical symptoms, and practical manifestations in the life of the parties. Our experts classify psychological disorders with the DSM-5, that is, the fifth edition of the Diagnostic and Statistical Manual of Mental Disorders of the American Psychiatric Association. Valuable as it may be, this manual is not binding for us. We only use it as a reference tool. We are not so concerned about the scientific classification of the disorder. The nature of the anomaly is not as important for us as its impact on the superior faculties. Any psychological problem, perpetual or transitory, can become a grave anomaly as long as it gravely impairs the superior faculties. The identification of the anomaly is just the first step. Once the anomaly is clearly identified, we need to study how it influenced the intellect and the will. We need to study the particular circumstances of the case and make sure that the person was really unable to engage the superior faculties to elicit a human act of matrimonial consent. This is also why the psychological evaluation of the expert is not a judgment on incapacity. Even if the expert confirms the existence of a grave disorder, the judge will have to decide if there was incapacity. The expert knows about psychology, but incapacity is a legal matter. The question that really matters is if the person was able to establish the legal bond of marriage. In other words, the question is if the person was able to understand, will, and assume the essential rights and duties of marriage. 3. Lack of sufficient use of reason. The first ground of incapacity is a traditional one. Indeed, sometimes it is manifest that a person is completely impaired. For instance, those who are drunk or suffer from the most severe intellectual incapacities are unable to marry. In fact, they are so deprived of the use of reason that they are unable to celebrate any legal contract at all. This very manifest incapacity configures a ground that has been used traditionally under the name of amentia, or lack of mind. The ground of insufficient use of reason can be used for severe intellectual disabilities, but we rarely see these cases. These persons are usually not admitted to the celebration in the first place. The ground is employed as well to address very apparent temporary impairments, like for instance, when they are under the influence or when they suffer an epileptic attack. In our recent experience, we have only used the ground of Canon 1095 first for cases of cannabinoid and opioid intoxication. Case 1. Tom was never a frequent user. He had smoked marijuana a few times in his life. But on their way to the wedding, his cousin Timmy lit up a joint to take the edge off. When they arrived at the chapel, big loads of smoke blew out of the car as they opened the doors and stumbled outside. Tom was so high that he could not hear the priest asking for his consent. Timmy tapped Tom in the elbow, and Tom looked up slowly. Then he stared at the priest for a good 10 seconds and calmly answered, "I do," with a big silly smile and his eyes injected in red. Case 2. Shannon and Phil were victims of the opioid epidemic of the 2000s. They were always high or sick. They were the typical codependent couple of drug addicts. At some point, they decided to get married, so relatives and friends gave them plenty of gifts and money. They spent it all on OxyContin pills. They were so high at the wedding that they didn't even remember the celebration. 4. Grave defect of discretion of judgment. Grave defect of discretion is by far the most frequent ground in ecclesiastical tribunals, but it is relatively new. It began to be considered by the middle of the 20th century, thanks to the contributions of psychological sciences. A more nuanced analysis of human action allowed us to understand that some anomalies can limit the ability to understand or choose marriage, even if they do not incapacitate the person completely. This ground takes place when a grave defect impairs our discretion. Now, our discretion is always defective to some extent, but this does not mean that we are incapable. Incapacity happens when the defect is grave and the anomaly penetrates the superior faculties in such a way that the act can no longer be called human. However, This is not a general and absolute impairment like we saw with the previous ground. The incapacity of Canon 1095 second is specifically about the perception of the essential matrimonial rights and duties that the spouses exchange at the time of the wedding. In other words, the psychological anomaly makes it impossible for the person to understand correctly or to will freely these essential rights and obligations. While this is clear in theory, it is not so easy to apply to the particular case. Incapacity grounds are difficult grounds. For instance, even if it is evident that someone suffered from depression at the time of the wedding, it may not be clear to what extent the depression impaired the judgment and the ability to understand the fundamental duties of marriage. The anomaly is not enough, and it is not enough that it affects the intellect and the will. The anomaly must make the person unable to assess the essential content of the matrimonial contract. Typically, jurisprudence describes the grave defect of discretion as a defect that makes matrimonial consent not conscious, deliberate, or free. Conscious means aware of the rights and duties exchanged in the consent and its essential implications. Deliberate describes the evaluation of the act of consent and the awareness of the practical obligations that it entails. Free means without internal coercion or pressure. Intellect and will are not two individuals who exchange information or talk to each other. They are two metaphysical faculties, and there is a constant and dynamic exchange between them. Therefore, whenever an anomaly affects either faculty, it affects both faculties. However, in some cases, the anomaly influences the will more directly, limiting the freedom of the consent. For these cases, jurisprudence has called this lack of internal freedom, which is a subspecies or type of grave defect of discretion. Case 3. Sonia is bipolar. She has struggled with it her whole life. When she was 25, Sonia went through a very difficult time and she didn't take her medication for several months. She had very high highs and very low lows. During that difficult period, she met a man at a bar and felt desperately in love with him. 1 week later, she asked him to marry her, and they did it right away. At the wedding, Sonia was euphoric. They broke up 1 month later. Looking back, Sonia realizes that she was not herself at the time. In her own words, it was the worst mistake of her life. Case 4. Lack of internal freedom. Teresa was raised in a very strict traditional home. Premarital sex was openly and harshly criticized by her parents. When she was little, the neighbor's daughter got pregnant and they kicked her out of the house. Teresa suffered as well from a feeble constitution. Her mother's character and stern way of raising her contributed to a number of psychological disorders, which she only understood in full much later in life. Among other problems, she certainly suffered from a generalized anxiety. When she was a young girl, Teresa had a boyfriend called Pedro, whom she saw behind her mother's back. They saw each other a few times, and they had sex once. After that, Teresa felt so guilty that she decided to break up with him. A few months later, another boy came up to her and asked about Pedro. Teresa answered that they were not together anymore. He looked back at her with incredulous eyes and said that a woman must be always with a man once he has had her. Teresa blushed immediately as she understood that it was public knowledge that she was not a virgin anymore. Immediately, she went to look for Pedro and did not stop until he agreed to marry her. She did it all out of pure anxiety and fear. She was so terrified that she lost 20 pounds. 5. Incapacity to assume the essential obligations. The first two grounds of incapacity share the same dynamic. The anomaly disturbs the decision-making process by which the intellect and the will arrive at the consent to marry. This third ground of incapacity comes from a different cause: the incapacity to fulfill the essential obligations of marriage. Indeed, nobody is bound to the impossible, ad impossibilia nemo tenetur. Impossible promises have no value. Difficult promises do, but not impossible ones. If I promise to give you $1,000, I owe you $1,000. But if I promise to give you the moon and the stars, I owe you nothing, because it is impossible for me to do such a thing. Since it is impossible, I cannot assume the obligation of doing it, and my promise to do it, even if I uttered it, is invalid and worthless. Matrimonial consent is a promise. The promise is implied in the permanent nature of the contract. The spouses agree to remain in the partnership and to give each other the rights of marriage until death. Since marriage is a promise, those who are unable to fulfill the promise are incapable of marriage. As we said above, incapacity and difficulty are different. Fulfilling the obligations of marriage is never easy. In real life, couples struggle to help each other, to raise the children, to be faithful, etc. Sometimes they are defeated by the struggle and their marriage fails. But that does not mean that they were incapable. Incapable is the person who cannot, despite all efforts, fulfill one or more of the essential obligations. We began the lesson with an explanation of the adequate anthropology behind canonical marriage legislation. According to this anthropology, humans are usually capable of marriage. We presume that marriages are valid until the contrary is proven. When it comes to the ground of 1095 two things need to be proven. First, it must be clear that there was an anomaly. Second, it must be clear that the anomaly made the fulfillment of the essential obligations impossible. The anomaly must be present at the time of the wedding. Otherwise, if it appeared after the wedding, the person was not incapable when the marriage was celebrated. Sometimes, however, the anomaly was present, but only in a latent way. For instance, an addiction that was already present at the time of the wedding, but not fully developed. The incapacity to assume takes place at the time of the wedding, not during the marriage. The marriage is not invalid because the person failed de facto to fulfill the obligations. The marriage is invalid because the person was incapable of assuming them at the time of the celebration of the contract. The fact that the obligations were not fulfilled is a manifestation of the incapacity, and therefore it is very relevant for us. However, what really matters is not the behavior during the marriage, but the capacity at the precise time of the wedding. Incapacity to fulfill and incapacity to assume go hand in hand. Fulfilling and assuming are two sides of the same coin. In other words, I can assume today because I can fulfill from today on. I assume today the duty to fulfill from today on. In our explanation of grave defect of discretion and incapacity to assume, we have referred many times to the essential obligations of marriage. You are probably wondering which obligations are essential to marriage and which are accidental. There is no easy answer. Certainly, the duties of marriage are related to the nature of marriage. Since marriage is an indissoluble and exclusive partnership open to procreation through sexual intercourse, the obligations of marriage are to be faithful, to care for the other spouse, to nourish and rear the offspring, etc. However, these are general notions. When we descend to the practical cases, it may be difficult to know whether a certain obligation is essential or not. For instance, it is quite clear that adultery is an essential violation of the duty of marital fidelity. But there are non-essential transgressions against the general duty of fidelity, like for instance a short gaze at someone attractive at the mall. The bottom line here is to use your common sense. There is no official criterion to decide what transgressions are essential or not, but most times this becomes quite clear when we examine the particulars of the case. Case 5. Wilson was attracted to other boys since he was very young. He knew he was gay since he was a teenager. But his grandmother asked him to find a good wife and give her great grandkids. Wilson loved her so much. His grandmother had raised Wilson and his siblings on her own with love like a true mother. Wilson didn't want to upset her, so he found a girl and married her. On the day of the wedding, he was convinced that he wanted to do this as a sacrifice of love for his dear grandmother. He really was committed to be a good husband and a good father, but he just couldn't. When they were together, Wilson felt nothing, no attraction at all. They barely had intercourse a few times with great difficulty. Wilson's wife was suffering because she didn't feel attractive. It was a living hell. After a few years of marriage, she caught him having intercourse with other men, and she left. Case 6. Harry started drinking when he was deployed in Vietnam. He was only 17 at the time. On the first day of deployment, he witnessed the death of a Vietnamese boy who was riding a bike. The soldiers took him for a suicide bomber and shot him dead on the spot. The child's mother and sister were there, wailing in despair over the warm corpse. Harry was never the same. He came back addicted to alcohol. Karen married him because they had been together since high school. But they were only happy for a couple of weeks. When Harry was sober, things were okay. But as soon as he would touch the bottle, he'd lose his temper and become violent with Karen and the kids. Karen left 4 years later to protect herself and the children.